Swayam Prabha. Digital India. Educated India.
A of IPC is to be taken as Section 85 and 86 of BNS, and Section 494 of IPC is to be taken as Section 82 of BNS.
Hello everyone, this is Professor Shivani Goswami and I'm teaching in IP University. We had started with the Hindu Marriage Act, and in my previous lectures we had discussed various important sections of the Hindu Marriage Act, and in my previous lecture we were talking about judicial separation and divorce, which again is very important as far as the act is concerned. I talked about that as far as judicial separation and divorce are concerned, they are two distinct things. Although if a layman sees it, judicial separation, obviously he'll think that this is divorce only, but there are two distinct things. One is dealt under Section 10 of the Hindu Marriage Act and the other one is dealt under Section 13 of the Hindu Marriage Act. Though the grounds are same, but the repercussions are different. I had told that judicial separation is a lesser evil than the divorce, because in judicial separation the marital ties are just suspended. You still are husband and wife. A time period is given to you to reconcile your differences, to reconcile between yourselves, to reponder, to rethink about your relationship, and reconciliation is also possible. But when you talk about divorce, which is mentioned under Section 13 of the Hindu Marriage Act, we discussed about the 8 grounds, because earlier leprosy was a ground of divorce, but now this has been done away with. We have 8 grounds which are available to both the husband and the wife, and 4 additional grounds are available only to the wife and not to the husband. In divorce, it's a greater evil, and I have my reasons behind it. Because why I am saying so is because after divorce, the parties are it's a complete dissolution of marriage, and the parties are free to go their own way, and now there is no tie between your ex-husband or ex-wife, as the case may be, and it is considered to be more, after this you cannot do anything. But in judicial separation, you still have time to maintain your relationship, to sustain your relationship, which is not the case as far as divorce under Section 13 of the Hindu Marriage Act is concerned. So that was Hindu Marriage Act. I had taken 4 lectures on that. Today is my 5th lecture, and I would be starting with the new act, again an important act under Hindu law, that is Hindu Adoption and Maintenance Act 1956. Now, if you see the acts, this act itself is speaking about, it says that Hindu Adoption and Maintenance Act. So that means this act would be dealing with 2 aspects, that is adoption. Number 1 is adoption, and second one is maintenance. If you see the scheme of the act, in my slide it is there that chapter 1, that is preliminary, it deals with section 1 to 4. Chapter 2, 5 to 17, it talks about adoption. Chapter 3, section 18 to 28, it deals with maintenance. And the last 29 and 30 sections, they deal with repealing and saving. To begin with, the Act, Section 1, as it is always there in all the Acts, we say that it is called as the Hindu Adoption and Maintenance Act 1956. It is applicable throughout India except for the state of Jammu and Kashmir. Now again, this Act, it came into force. This Act is called as the Hindu Adoption and Maintenance Act. It came on it received the assent of the President on 21st December 1956, and it is applicable to all the Hindus within the territory of India. Who is a Hindu? We have already discussed in detail when we were discussing about under section 2 of the Hindu Marriage Act. I had already stated that Hindu is a person. It could be Hindu by religion, Hindu by birth, it could the persons who are not Muslim, Christian, Parsi or Jew. So that is the same. Whatever was there under section 2, obviously in my very first lecture only I have told that these acts, now whether it is the Hindu Marriage Act, whether it is Hindu Adoption and Maintenance Act, whether it is Hindu Minority and Guardianship Act, the word everywhere that is used is Hindu, Hindu, Hindu. So that means, and the definition of Hindu, I had told you that there is no direct definition of Hindu. It says that, the act says, who are the persons on whom Hindu law applies. And when you come to the conclusion that these are the persons on whom Hindu law applies, you come to know that these are Hindus. So it could be Hindu by religion. We have studied about Hindu, Sikh, Buddhist, Jain by religion. That is Hindu by religion. Hindu by birth. When both the parents are Hindus, obviously the child is a Hindu. When one of the parents is a Hindu and the other belongs to a different religion, the child would be a Hindu provided he is brought up as a Hindu. So the religion would be the way you are being brought up. It is not the way that we see that India is a male domineering society, it's a male dictated society. So whatever would be the religion of the father, that would be the religion of the child. It is not like that. If the father and mother, they belong to different religion, the religion of the child would be according to the way the child is being brought up. So if the child is being brought up the way, if a mother is not a Hindu and he's brought up in that manner, the child would not be a Hindu. It is the way the child is being brought up when the parents, they belong to different religion. And the last one was, who's not a Muslim, Christian, Parsi or Jew, but who have been governed by Hindu law earlier, so they are also Hindus. So even under your Hindu Adoption and Maintenance Act, it remains the same. Hindus are these persons only, and this act of 1956 is applicable to these persons who are Hindus, because it says that Hindu Adoption and Maintenance Act. So the word Hindu is very important. It is applicable only on Hindus and not to any other religion. If you see the application of this act, I have already explained it to you that section 2 is talking about this thing, that it is applicable to Hindus only, and who are Hindus, I have already discussed about this thing. Now when we talk about what is adoption, every now and then we hear of this word, what is adoption, and we say that this child has been adopted. He is an adopted son of this person. He is an adopted daughter of this person. So if we talk about adoption in a layman's language, or just if we say so, it could be that when you are giving a child from his natural family and you're taking the child from the natural family and giving it in the adoptive family, that basically is adoption. So that means adoption is of a child. As far as the act is concerned, it specifically says that only children till the age of 15 years can be adopted. So all those children who are below the age of 15 years, they can be adopted under the act, that is Hindu Adoption and Maintenance Act 1956. And if, though in some cases even married people are adopted, and but that would, if the custom allows so. So this is very important here. If we see it, adoption is when you are taking the child from his natural family and giving an adoptive family, it is called as adoption. There has been a lot of difference when we talk about the pre-act and the post-act position relating to adoption. Pre-act, I mean to say, before the act came into operation, I have already told that this act of 1956, it received the assent of President on 21st December 1956, and so that means all those adoptions which were taking before this particular date and the adoptions taking place after this particular date. If you see my slide, I have just put the position as pre-act and post-act position. Earlier, when we talk about, it was only, we used to say that in the pre-act, it was more of a spiritual kind of a thing. People just used to adopt son. So that means daughters were not adopted. The purpose could be because we have this belief that it is the son who carry forwards your legacy, number one. Number two is, it is the son who is going to burn the funeral pyre. So basically, the purpose was this only, that people used to go for adoption of son, and daughters' adoption was not recognized. It was not allowed. Then there is one concept of consent in case of a married person. Earlier, it was only the male who could be adopted. I mean, a male person only can adopt a child. Then in the case of a married man, now the act says, the 1956 act says that if you are a married man, you can adopt, but you need the consent of your wife. You have not taken her consent, that adoption is no adoption in the eyes of law. If you are a single person, you could be a divorcee, you could be a bachelor, you could be a divorcee, bachelor, or a widower. That means there is no single person, you are a single person, so in your own capacity, you have got a right to adopt a child. But the Act says, if you are a married person, then you need to take the consent of wife, and it is a mandatory requirement. So under this 1956 Act, consent of wife in case of married person is a mandatory requirement. It's imperative. You have to take it. So if you do not take it, that means that adoption is no adoption in the eyes of the law. Earlier, it was only as far as the illegitimate children and all those were concerned, they were not adopted. But this Act doesn't restrict. It doesn't put any restrictions. Whether it's an illegitimate child could also be adopted. Whether it's a foundling. Foundling are the children you found it on the road, something like that. Orphans. Earlier we didn't adopt orphans children. But now these children can be adopted. Earlier, as far as the ceremony is concerned, Dattak Homam was essential, but now it is only the ceremony of giving and taking that is mandatory. Dattak Homam has been done away with. Then there is also a requirement as to age. Age in the sense that if a person adopts a person of opposite sex, then it is necessary that there needs to be an age gap of 21 years. Now, it's a statutory requirement. Why it is so is so that there is no sexual molestation, and in order to avoid these kind of things. So this huge, it's a gargantuan age gap. This age gap has been kept, but it is only in the cases when you need to adopt a person of opposite sex. So that means if a male is adopting a female child, an age gap is of 21 years. Similarly, if a female is adopting a male child, the age gap should be of 21 years. It has to be of opposite sex. So that is a statutory requirement, and this is regarding the pre-act and the post-act position. Overriding effect of the Act, section 4, it talks about the overriding effect. It was also there under the Hindu Marriage Act. Basically, it says that all those customs, laws which are inconsistent with the provisions of Hindu Adoption and Maintenance Act 1956, they have to go away. Now it is the provision of Hindu Adoption and Maintenance Act only which will be governed and which will be taking place. So any inconsistency with the provisions of this Act now is no more applicable, and it is the Act which is prevailing and not the inconsistency. That is so that means that custom, laws which were inconsistent with this present Act, they have to go away if there is an inconsistency. It is this Act from this particular date which will now be operative, and the provisions of this Act now would be applicable after that particular date of 21st December 1956. Options of course is to be regulated by this chapter. Section 5 is again that I have already told this thing that you need to, all adoptions that are taking place now has to be governed according to the provisions of this particular Act of Hindu Adoption and Maintenance Act 1956. So it has to be regulated by this chapter. If at all you have to adopt a child, you need to see the provisions of Hindu Adoption and Maintenance Act 1956, and it has to be governed according to the provisions of this particular Act. Now section 6 again it talks about the requisites of valid adoption, and in my slide it could be seen that section 6, if we read this section, first I'll read it and then I'll just show the requirements. Section 6 says, no adoption shall be valid unless 1. The person adopting has the capacity and also the right to take in adoption. The person giving in adoption has the capacity to do so. Third is the person adopted is capable of being taken in adoption. And fourth is the adoption is made in compliance with the other conditions mentioned in this chapter. Now, this chapter is basically the requirement of a valid adoption. It basically talks about the capacity and the right of a person to take a child in adoption. And this is what section 7 and 8 of the Hindu Adoption and Maintenance Act is talking about. It also talks about the capacity of the person to give a child in adoption. This is what section 9 of the Hindu Adoption and Maintenance Act is talking about. this act also talks about who are the persons who could be adopted, and that is provided under section 10 of the Hindu Adoption and Maintenance Act, and other conditions relating to adoption are mentioned under section 11 of the Hindu Adoption and Maintenance Act 1956. Now when we talk about section 7, that was section 6, if we talk about section 7, it basically talks about the capacity of a male Hindu to take a child in adoption. Now, first I will read it and then I will explain it. Section 7 says, any male Hindu who is of a sound mind and is not a minor has the capacity to take a son or daughter in adoption. Now, there is a proviso attached to it. It says that if he has a wife living, he shall not adopt except with the consent of his wife, unless the wife has completely and finally renounced the world, or has ceased to be a Hindu, or has been declared by a court of competent jurisdiction to be of unsound mind. Now, when you talk about section 7, it talks about the capacity of a male person to take a child in adoption. So, it says that any person who is of a sound mind, that means an insane person cannot adopt a child. The requirement is you need to be of a sound mind, and the presumption is always in favor of sanity of a person. Any person who is of a sound mind and is a major, again majority has to be governed by the Indian Majority Act, and the person who is 18 or above years of age is a person whom we say that is a major. So that means the requirements are the person should be of a sound mind, he should be a major, and only then he could take a child in adoption. That's a requirement. Then in the case of male, if we categorize the male, we have 4 categories under it. A male can be a divorcee, he can be a bachelor, he can be a widower, and he can be a married man. So that means 4 categories of men are there. In the first 3 cases, when he is a single person, that means when he is a divorcee, when he is a widower, or when he is a bachelor. In all these cases, he has got in his own capacity to adopt a child. A child could be a son or a daughter, a male or a female, as the case may be. So in his own capacity, he doesn't have to take consent of any person. In his own capacity, he can adopt a child, a male or a female. Now, in the case of a married man, now it constitutes an exception that if a person is a married man, he needs to take the consent of his wife, and the consent is a mandatory requirement. In all those marriages that took place before 18th May 1955, now why I am stating this particular date is because this particular date, before this date, it is on this date that the Hindu Marriage Act came into existence. So that means before the Act, Hindu Marriage Act talks about monogamy, which we have already discussed under section 11 of the Hindu Marriage Act. Now, those marriages, that means the marriages that took place before this act, you could go for bigamy, you could go for polygamy. Monogamy became the law only after 1955 Act came into existence. But before this, a person could go for number of marriages. So if a person has number of wives, say 2-3 wives, then and it is applicable only for the marriages that took place before 1955, because after 1955, if you go for another marriage, that marriage is no marriage in the eyes of law. So the marriages that took place before 1955, and if there are 2-3 wives, he need to take the consent of all the wives. That is again a requirement, and if he takes the consent of one wife and doesn't take the consent of another wife, that adoption is not valid in the eyes of law. Now, it could be, the consent could be expressed or implied also. If the wife is sitting with you when the adoption, that means it's an implied consent. Expressly, so you can always ask, and if she has a consent, that's well and good. Now, the consent of the wife can be dispensed with only in 3 exceptional cases. Number 1 is If the woman is of unsound mind, she has been declared by a court of competent jurisdiction to be of unsound mind, she has ceased to be a Hindu, or she has renounced the world. In these three exceptional cases only, the consent of the wife can be dispensed with, and if none of these situations is prevailing, the consent is a mandatory requirement. I talked in my previous lecture that if it is a case of judicial separation, the marital ties are just suspended. So that means in that case also, if you are adopting a child, you need to take the consent of that woman, the wife of yours, because she is still your wife. It's a case of judicial separation. Marital ties are suspended, they are not dissolved. And so in these cases, you need to take the consent of this woman. In the case of voidable marriage, if the marriage is not annulled, that means it is completely a valid marriage. We have discussed voidable marriage under section 12 of the Hindu Marriage Act. There were 4 grounds. I hope you remember those 4 grounds. So in all those cases, if the marriage has not been annulled under section 12, it's a case of voidable marriage, you need to take the consent of the wife of yours. She's still your wife. It's a valid marriage till it is annulled. So you need to take the consent of this woman. If a male has to adopt a female child, I have already told this thing, that means a male is adopting a person of opposite sex. There needs to be, a statutory requirement is, there needs to be an age gap of 21 years. It's a statutory requirement. So this is regarding a capacity of a male to adopt a child. So as a male has a capacity to adopt a child, similarly a female also has a capacity to take a child in adoption. Earlier, before amendment, the female just had to give her consent. It was always the men who used to adopt a child. Only the consent of the women was there, the wife was there. But now an amendment has been made, and even a woman can in her own capacity adopt a child. So even if it is a married woman, she can adopt a child, but the only requirement is that she needs to take the consent of her husband. And again, the consent of the husband would be dispensed with in 3 cases, which are renunciation of the world, you have ceased to be a Hindu, you have been declared by the court of competent jurisdiction to be of unsound mind. In only these 3 exceptional cases, the consent is not required of the husband. Otherwise, women can take the child in adoption provided the consent of the husband is there. That is a case of a married woman. Now, women can also be a divorcee, she can be a spinster, she can also be a widow. In these cases, when she is a single woman, she need not take the consent of anyone. She can, in her own capacity, adopt a child. So that is allowed. Earlier, it was not allowed. There was a concept of doctrine of relating back. If a female adopted a child, the child and her husband, only a widow could adopt it, and it was, the child was adopted in the name of her husband, deceased husband, and he was deemed to be adopted from the date of the death of the husband, and it was adoption by her, but it was not adoption to her. It was the name of the husband only. So that was doctrine of relating back. Now that has been done away with. The females, they in their own capacity can also adopt a child, whether a male or a female. Again, the requirement is there. If the female has to adopt a child of an opposite sex, that means if she has to adopt a male child, the age gap of 21 years is a mandatory requirement. So that is also there in the case of female. Now, section 9 talks about persons who are capable of giving a child in adoption. When we talk about giving the child, because one is a taker and the other is a giver, the ceremony of giving and taking is what adoption is, and that is the only requirement. Dattak Homam has been done away with. There were oblations to the fire. Now this has been done away with. Now, we had talked about the persons who could take the child in adoption. There are also persons who could, obviously there would be persons who would be giving the child in adoption. So this right is available to the parents, so it could be father, it could be mother, and even guardians are allowed to give the child in adoption. So similarly, in this case also, a father has got a right to give the child in adoption of a son or a daughter, and he needs to take the consent of the mother of the child, that is his wife. That is the requirement. The consent could be dispensed with in those 3 cases which I have already told you. So he is allowed. Similarly, a mother of the child is also allowed to give the child in adoption, but she needs to take the consent of her husband, and after the consent is taken, she could do it, and if those exceptional cases are there, then the consent is not required. Now, one important thing under it is, which was not there earlier, that guardians are also allowed to give the child in adoption. Now, guardians, I mean to say here, it could be your testamentary guardians, it could be your certified guardians, that is the guardians appointed by the court. Testamentary guardians are the guardians appointed by the will. It could be the in charge of an orphanage. Now, we see so many children. You could see in my slide, it's written that when can guardian give. So, if the diagram shows both the parents are dead, both parents abandon child, both parents renounce the world, both parents unsound mind, and child parentage is not known. So, if it is a case of an orphanage, the guardian, the in charge of that orphanage, has also got a right to give the child in adoption. But one requirement under it is that if a person from an orphanage has to give the child in adoption, prior permission of the court is necessary. That's a mandatory requirement. So, prior permission of the court is there so that the court sees, it is always, whenever we talk about the child, it is always seen that the welfare of the child is paramount. So, it might happen because he's not his own child, the guardian can give it like that only, without looking into the background of a person to whom the child is being given. So, the intervention of the court in this, the prior permission of the court, is a necessary requirement when the child, has to be given through an orphanage. So, prior permission is a necessary requirement, which is not the case when natural guardian of the child, they are giving the child in adoption. But here there is a flaw in the sense that what we feel is that even the intervention of the court should be there. Why I am saying so is, I have my reasons behind it, that sometimes due to circumstances, the person, without seeing the background of the family where the child is to go after adoption, give it. It could be, for example, there is a young widow. Now, she has to marry further, and we do see every day that people do not like or do not want to marry a person with a child. So, she might in a hurry give the child in adoption just to see her future, and without forming the background, without seeing the background of that family, she would give it in a hurry. Then there could be that there is extreme poverty, and due to that you are taking money for that, and without, there was one case, it was of Odisha, where a woman, just for rupees, she was very poor, there is a lot of poverty, and just for rupees 50, she gave the child in adoption, and without seeing what was the background of the family where the child has been. So, it is not necessary that court intervention is required only in that case. It should also, though it is not there, the law doesn't say so, it should also be there when the natural parents are giving the child in adoption. When we talk about the welfare as a paramount thing, I think this should also be there, that welfare requires that even in those cases, because you never know what are the circumstances of the parents when they are giving that child in adoption. Then it talks about section 10. I have already told you that persons who may be adopted. Of course, a child, now it is a male or a female, can be taken in adoption. It's not that only sons would be adopted, even daughters can be adopted. So, and then it is also a requirement, because it's Hindu Adoption and Maintenance Act, that the child should be a Hindu. Now, who is a Hindu? We have already done that thing. Child can be adopted only once. It is not possible that once you have adopted and you feel that the child is not according to your expectations, you are giving the child to another family, that you take it now. Once adoption is made, it is made once for all. Now, whether the child is good, whether the child is meeting your expectations or not, that is totally immaterial, because it is given only once. After that, you cannot further give the child in adoption. Must be unmarried. It is not, in some cases, if the custom allows, even married persons are also given in adoption, for example, in Bombay, Punjab. So, these are certain places where exceptions are there, and 15 years of age is the requirement. I have already told this thing, that the child should be below 15 years of age. So, that means only children up to 15 years of age could be adopted. Then section 12 basically talks about the effects of adoption. After the adoption has taken place, all ties of the child in the natural family are broken. Now he is a child in the adoptive family. For all purposes, for all legal things, he is a child in the adoptive family. There is only one tie after adoption that remains, which is not broken. The thing is that now also he cannot marry any women in the natural family which fell within the prohibited degree. So that is the only tie that remains. Otherwise, after adoption, all ties of a child are broken and he becomes a member of the adoptive family. So your adoptive father, he's your adoptive father. The mother is adoptive mother. The siblings are your brother and sisters. So it is as good as if the child is now born there. So all ties in the natural family are broken and only this tie remains. Then when we talk about the liabilities, responsibilities, an adopted child being at par with the natural born child. So in the cases of maintenance, in the cases of inheritance, this child has similar rights to what the Auris Putra or Putri or natural born child is having in that family. So there is no demarcation, there is no distinction, there is no disparity as far as this thing is concerned. Whatever rights and obligations the children or natural family have, now this adopted child also have. He has inheritance rights, he has maintenance rights, so he could also claim maintenance the way they are claiming. Similarly, then when he grows up, he is also liable to maintain the parents if they are aged or infirm. So all those liabilities and responsibilities are at par to whatever the natural children in that family are having. He also has the same responsibilities and liabilities. Then there is one thing that supposingly, let's take an example here. Before adoption, there's a family, let's take a family. A is the father, B, C and D are his children. Now, if the property is divided, it will be divided into 4 parts since there are 4 members. So it would be 1 by 4, 1 by 4, 1 by 4, 1 by 4. Now say B, this is before adoption that the property has been divided. Now after the property is divided, say B is given in a family F. He is given in that family. So whatever property he has got here, now it is not that he will have to leave this property in a natural family and he will have to go empty hand in that adoptive family. This property which is given to him is before adoption. So this property is his and he can carry that property forward to that family also. And had it been that he had been earlier given in adoption and the property in this natural family was divided later on, then he doesn't have any right in that property. Then similarly, in the adoptive family, say this person is a son, that woman in F is the woman and she has 2 daughters, F1 and F2. Now they have divided the property amongst themselves and there is no adoption till yet. So since there are 3 members, it would be 1/3, 1/3, 1/3. Now when he is going in that adoptive family, the property is already divided in that family. Now after adoption is taking place later on, he cannot tell them that now the property needs to be redivided because now also I am a part of this family. Because the property has been divided before his adoption, so he cannot divest them of that property. But if he goes to that family and after he has gone, he has been adopted in that family, after that the property is divided, then very much he will get a share in that property because now he is a part of that family. So that is what the thing is in the case of divesting of the property. There are other conditions also for valid adoption. For example, it says that, the section says that, section 11 talks about this thing, that if you have a son, son, son or son, 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 it could be legitimate, it could be by adoption, then you cannot adopt a son. You can adopt a daughter, but you cannot adopt a son. If these persons, they have ceased to be a Hindu, then it's a different requirement. Then you can adopt. Then similarly, if you have a daughter or a son's daughter, you cannot adopt a daughter. You can adopt a son, but you cannot adopt a daughter because there is already a daughter in the family. It could be legitimate, it could be by adoption. The things are different if you have ceased to be a Hindu. Then it says that, I have already told this thing, 2 persons, if they are of opposite sex, a male is adopting a female child, age gap is 21 years, female is adopting a male child, age gap is of 21 years. Then two persons cannot adopt the same child. Now, two persons here could be other than the husband and wife. Obviously, husband and wife, they constitute one family. It has to be, it cannot be, like, let's take an example here, that if the brother of a sister, there are two brother sisters, the brother is adopting a child, and there is an agreement between brother and sister that 15 days I will be keeping child, another 15 days of a month you will be taking child. It is not there. It is, first it is made only once. You cannot go for adoption second time. That is the requirement. Second is, it has to be, it's only one person who could adopt a child. So that's a requirement. So two persons cannot adopt a child. Ceremony, there are no formalities that are required. It is only the ceremony of giving and taking that is a necessary requirement. Otherwise, earlier there was Dattak Homam also, that was oblations to the fire, that has been done away with. Now it is only ceremony of giving and taking. Then section 13 of the Hindu Adoption and Maintenance Act, it states that when you're going in an adoptive family and say your adoptive parents are having a self-acquired property, now they have got a right to dispose of the property the way they like, as we have it. We know that in ancestral property you have a birthright, but if it's a case of a separate or a self-acquired property, you do not have a birthright. So this adopted child cannot divest them. If they are making a will, they have full right to give it to anyone. Similarly, like a natural child also cannot do it. So the same rights are also there in the case of adopted child. In the case of, then there are certain relationship, in the sense section 14 of the Hindu Adoption and Maintenance Act 1956 talks about it, that if a person is adopting a child, the wife of this person is the adoptive mother of that child. Then if the person have 2 or 3 wives, as was the case before the act came, Hindu Marriage Act came into existence, then the senior most by marriage, you need to see the relationship, is the adoptive mother, and all other females, that is the wife of that person, they will become the stepmother of that child. Then if a single person is adopting and this single person gets married later on, that later the spouse of this person would be the stepmom or father of that child. So that is the requirement, and valid adoption cannot be cancelled. That's very, because adoption is when you have complied with all those formalities of ceremony of giving and taking. Obviously, it cannot be cancelled. Once it is made once for all. Then there is presumption as to if a registered document is produced. We know that evidence, how much important part it plays. It could be oral, it could be documentary. If a documentary evidence is produced before a court and it is signed by the giver and the taker, there is a presumption that valid adoption has taken place. Now the burden of proof lies on the other party to show that it was not a case of valid adoption, because the presumption is always of the court. The court presumes that valid adoption has taken place. The last section of this adoption part is of section 17. It basically talks about prohibition as to certain agreements, in the sense that certain payments, in the sense that you are not allowed to take or give any money in consideration of adoption. So that is not allowed. When you are adopting a child, you are treating that child your own, and giving of taking or money for that purposes is a thing that is proscribed, that is forbidden, that is prohibited. So that is not allowed. So you're not allowed to give or take money in lieu of that adoption. So this is the adoption part. I have already told you that this act, it deals with 2 things, adoption and maintenance. The second part is of maintenance. Till 17, 1 to 17, we have adoption part, and from 18 and onwards, that is till section 28, it is maintenance part. We all of us know that every time we do hear that maintenance, she has maintenance liya hai, she has taken maintenance. Now maintenance is, and I have already told you that as far as maintenance is concerned in my previous lectures, that it is only the Hindu Marriage Act 1955 which talks about maintenance of both husband and wife. Either party can claim maintenance if they are not well off or they are not able to cope up. But in the case of Adoption and Maintenance Act and in the case of CRPC, it is always the wife who has got a right to claim maintenance and not the husband. Maintenance, in a layman's language, obviously, it is the necessities of life, the things that you need to sustain, the things that you need to live, the things that you were having when you were having a marital, you were living in that relationship, whatever standard of living was there, that needs to be maintained, and it's a provision for food, clothing, shelter, education, marriage expenses, so on and so forth, medical expenses, whatever are the basic necessities, that is what the maintenance is. So a person is liable to maintain certain relations. This slide is talking about who are these persons. It could be wife, it could be children and aged parents, it could be widowed daughter-in-law, and the fourth one is dependents of the persons whose property he has died, that I will be talking about. Now, this is what maintenance talks about, and these are the persons which are dealt under it and who can claim maintenance from a person. When we talk about maintenance of wife, Section 18 of the Hindu Adoption and Maintenance Act, it talks about that the wife of the person has got a right to claim maintenance from her husband. It's a personal obligation of the husband to provide maintenance to a wife, and it is not by any agreement. There is no agreement or contract that I will be providing you maintenance. It is out of the relationship of marriage. When you get married, it becomes your personal obligation to provide maintenance to your wife. So, when the woman is living with her husband, she's obeying, everything is okay, everything is, it is the obligation of the husband to provide maintenance to his wife. Under Section 18 Clause 2, there are certain cases when the wife has a ground to live separately and claim separate residence and maintenance from her husband. These grounds are, it could be desertion, it could be cruelty, it could be another wife is living, it could be concubine, it could be a venereal disease, whatever. We have studied all these grounds. But we have studied about desertion. I've told you that it is the abandonment of the spouse without the consent, without any reasonable cause. So, if the husband is guilty of this thing, then the wife can claim separate residence and maintenance from her husband. Cruelty is another concept. We know that the best definition that we do accept, although there is no definition of cruelty, it varies with circumstances. So, but we do say in Russell versus Russell, I had talked about this thing earlier, conduct of such a character as to have caused danger to life, limb, health, bodily or mental, or as to have a reasonable appreciation of such a danger. Although now it is that the person has treated the other person with cruelty, that is only the requirement. So, if the husband is cruel, is brutal, he is treating you with cruelty, it could be mental, it could be physical, then the wife has got a right to claim separate residence and maintenance from her husband. She has this remedy. Another wife is living, I mean to say, the marriages that took place, and or if he has, for that purpose, if he has gone for bigamy. I am calling it bigamy because you have performed certain ceremony. You had that first valid marriage, and in spite of having that first valid marriage, you have performed ceremonies with another woman. So, that's a case of a bigamy. So, if this wife is living, the women of this person, that is the legally wedded wife of this person, has got a right to claim separate residence and maintenance. Concubine. If a husband keeps a concubine, and that concubine is residing within the house, or she is residing somewhere else, then also the wife has got a right to live separately and claim separate residence and maintenance from her husband. You have converted to another religion, again a ground. So, in this also the person can, if the husband has ceased to be a Hindu, he has converted to another religion, the wife can claim separate residence and maintenance from her husband. So, these are certain grounds where the wife can live separately and claim maintenance, or even if there is any other justifiable cause. There could be any other justifiable cause also, and the court has to see that thing. The wife can claim separate residence and maintenance from her husband. So, she could live separately. However, this right would cease because it says that she is not entitled to separate residence and maintenance from her husband if she is unchaste or she has ceased to be a Hindu. If she herself has ceased to be a Hindu, she has converted to another religion, she has formally undergone ceremonies for conversion, then the husband is not bound to provide her separate residence and maintenance. Then that was regarding the wife. Section 19, it talks about maintenance of daughter-in-law. when I talk about maintenance of daughter-in-law, I mean to say maintenance of widowed daughter-in-law. Now, why I am saying so is because till the time the husband of the woman is alive, it is his obligation to provide maintenance to his wife. Now, if God forbid the death of the husband takes place, then the question is whether the father-in-law has got an obligation to provide maintenance to his widowed daughter-in-law. Now, here again, he has a remote obligation. I will not say it is his personal obligation or he has a remote obligation provided certain conditions are satisfied. Conditions it could be in the sense that the woman is unable to maintain from her estate, or she doesn't have any earnings from the estate of her husband, or his earnings from the estate of children or her children, or their earning, or it could be even the father-in-law has got a compulsory property, and if the woman has not taken a share, if she has not ceased to be a Hindu, then she can claim maintenance. But it is a very remote obligation of the father-in-law to provide maintenance to his widowed daughter-in-law. It is not his personal obligation to provide any maintenance to widowed daughter-in-law. The Act also talks about, under Section 20 of the Hindu Adoption and Maintenance Act, maintenance of children and aged or infirm parents. Now, children and aged or infirm parents, I mean to say that it is again an obligation of a person to provide maintenance to his children. Now, as far as the son is concerned, now here I will be dividing it between a son and a daughter. The person has to provide maintenance till the time he is a minor. Until and unless he is infirm, he is disabled, then it goes beyond minority also. In the case of illegitimate children also, it is still minority. Whether it is a son or a daughter, it's still minority. So, the person is under an obligation to provide it till minority. In case of an unmarried daughter, now he has to provide maintenance to his daughter till the time she goes for marriage. So, it is his obligation to provide maintenance to daughter. That means the father of this daughter has got an obligation to provide maintenance to unmarried daughter of his. Apart from this, it is also an obligation of a person to provide maintenance to aged or infirm parents. So, if the parents are unable to maintain themselves, then it becomes the obligation of the son, that is this person, to provide maintenance to his parents. And parents here would also include a childless stepmother. So, a stepfather is not included, but a childless stepmother, very well, she comes within the purview of this section, and a person is under an obligation to provide maintenance to such people. Then he also has got an obligation to provide maintenance to dependents. Now, the question here is 21 and 22 section, it talks about the dependents of a person. Dependents are those persons, they are the relatives of the deceased. Deceased is that the person who has died and he has not made a will, and his property had gone. Will in the sense, not will here exactly. The person has died, these are the relatives of that person, and they have not got any share in the property of the deceased. So, they will claim maintenance from the heirs of the deceased who have received share in the property. It could be, for example, a person has made a will. Now, dependents could be, for example, all your near relatives. It could be your wife, your children, your grandchildren, all those people. There's a list that is being provided, and you could see in my slide. They are all the dependents of a person. Now, they are also class 1 or class 2 heirs, as the case may be when we talk about this thing. Sometimes it might happen that the person has made a will and he has not given you any share in the property. Though you have a right, you being an heir, you have a right in the property of his, but because he has made a will, and will is always of a self-acquired property, so he has made that will and it comes into operation after the death of the person. Say he has stated, let's take an example here, after my death, his family constitutes mother, son and a daughter, and he has written in the will that after my death my property would be taken by my daughter and none else. Now, here they are all class 1 heirs. We will be studying under Hindu Succession Act 1956. They are all class 1 heirs and they are also the heirs of that person, but because he has stated in the will that my property would be going only to my daughter, so that means here the mother and the son, they do not get any share in the property. So, now here they are the dependents in a way that they can claim maintenance from the daughter, from the share that she has, although the daughter is not personally liable, but whatever share she has received, she can, it's not a personal obligation. From the share that she has received, it would be taken from that thing. So these are dependents who, though entitled to a share, but when they do not get it, they can claim maintenance from the heirs who have got the share in the property of the deceased. So that is what this section basically talks about. Then, as far as the amount of maintenance is concerned, it is at the discretion of the court to give maintenance. Now, the court takes into consideration various factors that has been provided under section 23 and 25 of the Hindu Adoption and Maintenance Act, and it could see the relationship, the closeness of the relationship with the deceased. It could see the wants of the claimant, the property of the claimant, what is his what was the standard of living, and it is the court which determines the amount of maintenance, taking into consideration the various factors which are provided under section 23 of the Hindu Adoption and Maintenance Act. And it is not necessary that whatever maintenance has been fixed, it remains once for all. It might happen today you are in a very good circumstances, your business is flourishing, you are rolling in money, so then the maintenance would be more. But it might happen, God forbid, that tomorrow you are not that flourishing and you see a downfall. So in these cases also, the court has got a right to decrease the amount of maintenance. So it is the discretion of the court, taking into consideration, it does not do it as whims and fancies. They take into consideration the various factors, and then it has got a right, it has got a discretion to increase or decrease the amount of maintenance as your circumstances permits you during that particular period of time. Then we have another one section of maintenance can also be claimed under section 125 of CRPC, and here also it is the wife, the parents and the children of a person who can claim maintenance under this particular section 125 to 128 of Code of Criminal Procedure, that is CRPC. Now here again it is necessary that the wife should remain loyal, she should not be unchaste, and the person is under an obligation to provide maintenance to this wife, legally wedded wife, even to a divorcee, till the time she goes for another marriage. So it's an obligation of this person to provide maintenance to her, and then he would be exonerated from providing maintenance if the woman is living in it. There are certain exceptional cases that are provided. If she is living in adultery, there has been a consent, mutual consent between the party, or she refuses to live with her husband without any reasonable ground, without any reasonable cause, then the husband is under no obligation to provide maintenance to his wife. Similarly, as far as the children or the aged or infirm parents are concerned, it is an obligation of the person to provide maintenance to them, and this because I have already told you that there are certain relationships where you need to provide maintenance. Your wife, your children, your aged or infirm parents. So in the case of wife, I have already told that there is no agreement that is being signed between the parties. It is always, when you are entering into a marriage thing, this marriage part only is important part, and by entering into this lawful wedlock, you are bound to provide maintenance to your people. It could be wife, it could be, so that is the thing which needs to be taken into consideration. So basically adoption and maintenance is talking about these cases. We have dealt with two important aspects today, that is adoption as well as maintenance, and this part, it's a very important part as far as, again, because we do see in our everyday lives that people are adopting children, but they have to go according to this thing only. And one important thing is that because it is Hindu Adoption and Maintenance Act, so the people which we are talking here, they are all Hindus. So that is not applicable. It's not, although 125 is one thing where it's a secular, this thing like CRPC I have told you, also. It is not only applicable to Hindus, it is also even Muslims and Christians, they can also do it because it is a secular provision. But when we talk about the provisions of Hindu Adoption and Maintenance Act, it is only the Hindus who could do it. And who is a Hindu? We have discussed it under Hindu Marriage Act, and that part, definition is not there. That part, the people on whom it is applicable, it is prevailing in all your Hindu acts, whether it is Hindu Marriage Act 1955, whether it is Hindu Adoption and Maintenance 1956, whether it is Hindu Minority and Guardianship Act 1956. So when the word is Hindu, it is, this thing is there, that these are the persons on whom Hindu law applies. Now I will end my lecture today on this note, and in my next lecture we would be discussing again on a very important act, that is Hindu Minority and Guardianship Act 1956. Thank you for the patient hearing. Thank you so much. In my next lecture we will be talking on Hindu Minority and Guardianship Act. Thank you.
I am A.K. Sharma and I am Professor of Sociology at IIT Kanpur. The question I am going to address is what is urbanization? Urbanization is essentially the process of population concentration, which means that if more people start living in a smaller number of places, or if the distribution of population becomes more unequal, like more people living in places like Bombay, Calcutta, Mexico, then we say that the urbanization is taking place. Essentially it means increase in percentage of population living in areas or localities which are defined as urban. Urbanization is a new phenomenon, of course, a post-industrial phenomenon. About 200 years ago, hardly 5% population of the world lived in urban areas, and today more than 50% population of the world is living in urban areas or localities which are classified as urban. You will be happy to know that according to 2011 census of India, in our own country for the first time, increase in the urban population has been greater than the increase in the rural population. Though India is not so urban as the developed countries, and about 31% population of India only is living in urban areas. We can believe that in 10 years, 20 years, 30 years time, India will also be more urban, at least more urban than what it is. It may not be 80%, but certainly it will be 35% or 40%. Now, how is this urban locality defined? Because this definition of locality as urban or rural is crucial to measure level of urbanization. I will give you definition of our own country. In Indian census, an urban locality is defined in two ways. There are statutory towns and there are census towns. All places with municipality, municipal corporation, cantonment or notified town area committees are called urban. This is statutory definition. According to demographic definition, there are three main criteria. If a locality has more than 5,000 people, or 75% of male labor force is engaged in non-agricultural activities, or the density of population is 400 per square kilometer or 1000 per square mile, then we say that the locality may be classified as urban. There are many other additions to this definition. Now we have the concept of urban agglomeration and many other things, but essentially this is how urban population is defined in India. And as I said that urbanization is associated with economic development and industrialization, same is the case with India. About 100 years ago in India only 11% people were living in urban areas, today 31% are living in urban areas, and this is obviously linked with economic development of the country, growth of per capita income and industrialization. I remember that in one 5-year plan it was mentioned that today this urban population can grow by way of natural increase of births minus deaths in the urban areas itself or through rural to urban migration. Today nearly 60% contribution to growth of urban population is due to rural to urban migration, and this is going to increase. This is essentially what urbanization means. Urbanization means growth of population in localities defined as urban in relation to population of localities defined as rural, and I have given you Indian definition. Thank you very much.